Hi, I'm Elizabeth Gearhart. I'm here with James Klobucar, Senior Associate at Gearhart Law, Intellectual Property Attorney. And I wanted to ask James some questions about design patents.
Absolutely.
So James, why would I get a design patent?
Well, I mean, if you ask me, I say, why wouldn't you, right?
Well, because I don't know what it is. No, I do, but most people probably don't.
Sure. I mean, there's a number of reasons why you would pursue a design, patent application and eventual patent. One of the reasons, one of the main reasons could be that simply you haven't really invented a new item, per se. You've just taken something and put a new spin on it, right? In terms of, design patents protect the ornamental appearance of something. And an example I give clients a lot to help them understand what a design patent protects is I just pick up pens out of the pen can in the conference room and say, well, here's two pens, each one has, individual, shell components. It has, the ink, and you click it, the spring, pushes it out. You can write with the ballpoint, etc. And I'm just like, but what's the difference between the two of them? And they're like, oh, well, one looks this way, one looks that way. Exactly. You haven't invented a new pen between them, but each pen design-wise is its own unique design, and that design is protectable separate from the function of the pen. And that's why you'd get a design on something. Also you'd get a design on something because really nowadays, in terms of what drives, a consumer to purchase something, I mean, people are visual creatures. They look for something that appeals to them. If they're dealt with two items that are fundamentally the same, will achieve the same end result, but one looks cool or one looks, better than the other, Apple maybe, if you're an Apple person, right? I mean, that's why people buy things. And protecting the ornamental appearance of what you have via design ensures that no one else can, really poach off of, that branding that you're, that appearance that you're bringing to the marketplace.
That's really perceptive. I mean, I have to plead guilty to oftentimes buying things because of the way they look, even.
Yeah, exactly.
So why wouldn't you trademark it, or would you trademark it too?
Certainly you could trademark, the name or a logo or a slogan, something that's associated with the product itself in some capacity. You could certainly, do that.
What about copywriting it?
It would depend. Copyrights are really good for artistic works that are fixed in some sort of a tangible medium, whether that's, architecture, sculpture, music, books, that sort of thing. There is some crossover and interplay between design applications and copyright. It's a bit more nuanced, I think, than what we would discuss here. But certainly, there is some overlap, but they're pretty distinct as well.
So how long does it take to get a design patent?
The time varies. Presently, I'm seeing we're waiting about a year to year and a half after filing before we receive the notice of allowance, after which you have to pay, the government issue fee, and it takes several weeks for the Patent and Trademark Office to print up and then send, the physical patent out to you.
And how much do they cost about?
Typically, you're looking at around $2,000 for us to prepare, for us to get the drawings done, and to pay the requisite government fees at the time of filing. Oftentimes, there are not really many substantive fees to be incurred after filing. I mean, there's some, but it's typically nominal fees. And unlike utility patents, once the design grants, there's no maintenance fees to be paid. So you don't have to worry about that or anything. It's just 15 years from the point that the patent is issued.
So how do those compare to utility patents, like price, time to get them, protection?
Yeah, I mean, each is a little different. In terms of cost, design patents are definitely going to be cheaper, primarily because the drawings form the heart and the claim of the patent for a design, as opposed to a utility, which is textual based. So the cost, again, for a design is going to be more in the 2,000 range. For a utility application, depending on complexity, you could easily be looking at 5, 6, 7,000 or more
To get it on file.
Right.
And then you have to prosecute.
Exactly.
Right?
And unlike, designs, which typically, I believe the first action allowance rate for designs hovers somewhere around 84, 85%, I think, at
So
present.
the patent office allows them right away.
Right.
Yeah.
Unlike utilities, where the inverse is true. 84%, probably even 90% or better, are getting first action refusals, at which point we're having to go back and essentially negotiate with the patent office to get it allowed, which results in additional, legal fees.
Most utility patents, applications that you send to the patent office, the examiner says, nope, you
Right.
cannot have a patent on this, and you have to come up with legal arguments,
Right.
basically, right?
Mm-hmm.
On why you can, and that costs money.
Exactly. Other differences, as we noted, the term of a design patent is 15 years from the point of issuance of the patent.
Oh, okay.
As opposed to utilities, which is 20 years from the point of filing.
Right.
So a little different there in terms of when you calculate that date. And then also a little different in terms of the overall length of time.
Okay. Would you ever get a utility patent and a design patent on the same invention? Do people ever do that?
Yeah, certainly people do that.
Why do they do that?
For a number of reasons, but predominantly it helps to add to the patent portfolio overall. Also, you may find that, someone is doing a one-to-one knockoff. Maybe they're trying to change up something to get around the utility patent while still trying to poach off of some of that branding, that appearance, that goodwill that's associated with your product. So that's going to help, negate people from, kind of trying to skirt the utility patent while still, maintaining some of the visual appeal, of the product. And then overall, like I said, it does add to the overall portfolio, the value of your company in the event that you ever, sell, or are acquired. It's a purchasable asset on top of that. It's something that's desirable to do. Something, that, and I'll bring this up, that people don't consider but should think about in these instances are a lot of times that people will try to use the same drawing set for each.
Right.
And they say, oh, it saves me money. It's a good thing. And it's not necessarily a good thing because design patents are supposed to be focused on ornamental appearance. It's supposed to be non-functional. And, utility patents are functional. What they're covering, is functional. And what ends up happening is that then these patents get litigated down the line and you've used the same drawings for each. And, whoever is on the other side, whether it's, defendant or plaintiff arguing against you, they're going to say, well, gee, if your design is non-functional, why are you using the same drawings that you're using for this functional application over here? And it becomes a bit of you can still get out of it. I mean, it's not a death sentence, but it becomes, a bit of an issue at times and it can be problematic. So, that's one thing that, people should think about and take into account if they are indeed going to do both. It's that old trap of, oh, well, I'll save some money here, but saving money here doesn't equate to, saving money later. Oftentimes it ends up costing you more. So it's better to, spend a little more and do it right, do it separately if you need to, than to try to skimp on costs.
I don't really think anybody except a design patent expert would know that or have thought of that, really.
Yeah, I mean, they may not. I mean, design patents are, their own quirk. And a lot of times, certainly when, new clients are bringing applications to us, sometimes it's design applications and someone else has filed it. You can pick up on, little issues here or there, or people that may not be as well versed in, design drawings that have missed. And, it can cause problems because you have a lot less freedom to make amendments to the application, unlike utility applications. Sometimes with design applications, if the drawings are fatally flawed from the start, they're fatally flawed, you can't fix it, and you just basically have to scrap it and try to start over. If you do that, depending on if the product has been in the marketplace already for over a year, now you're statutorily barred, by filing a new application more than a year after the product has been on the marketplace, and now you're in a world of hurt potentially. So, You know, so definitely want to be mindful, you know, of certain things.
So they're not as easy as they seem. So
they're not, no.
When I first became a patent agent and Richard was training me how to do patents, I was like, well, utility patents are pretty complicated and difficult. Yeah, design patents are easy. They're just a bunch of drawings. You know what? I quickly found out that was not true.
Yeah.
I mean, there's a lot more to design patents. And like you said, the drawings are crucial to get right.
They are.
For those.
They are. And it's, you know, it's crucial, and it's crucial that you have someone doing them that's experienced in doing them, because, you know, small things, you know, if done incorrectly, and inconsistencies between the views within an application can be very problematic. Oftentimes those are more correctable during the process of obtaining the application. But once the application's been issued as a patent and that's litigated down the line, it may end up with the patent being declared invalid.
Wow. And if you're already selling it, as James said, then if you've been doing it for more than a year, if you are selling your product for more than a year, you can't get a patent on it if you haven't filed yet.
Right.
And so it's just the same as if you haven't filed yet. So then you'll never get a patent on it.
Yeah, I mean, that may be the reality.
Wow. So if you want help with a design patent, James is happy to help you.
Absolutely.
He really is an expert on these. He's been doing them for a long time. And so we are here and happy to help you.